Yes, we're back again. Kristi and Katie, your crime time friends. Stories, justice, laughs collide. True Crime Squad, come join the ride. Grab the clues, let's take a stand. For victims' voices, hand in hand. True Crime Squad, it's time to shine. Season 6, your turn, your time. True Crime Squad, where justice meets hilarity.
Hey everybody, and welcome to the True Crime Squad. This is Katie Weaver. I'm here with my sister, co-host, and partner in crime, Kristi Brower. Hello.
Hello. Hey, everybody. Sandy, the True Crime Cat, also here with us. She's bothered to show up to work today. Some days she just doesn't show up. I don't know what to do. I don't pay her, so I don't know how to fire her.
But she's a cat. She will do what she wants.
She will definitely do whatever she wants.
I'm glad to be here. It's another Lori Vallow day. So I don't know. I mean, 2 in a row.
It's about to get Lori Vallow all day, all the time.
Yeah.
Trials
getting there.
So
well,
soon.
We'll find out. Depending on what the judge decides from the arguments that were made today. So
right.
We have plenty to share on that. But yeah, it's something.
Sad Willow, we are so happy to see you. People in our court have been worrying about you. I'm so glad to see you're here.
Good to see you.
Very happy to see you're here.
And hi to, is it Eli or Ellie? I'm going to say Eli from Norway.
Eli,
welcome.
Welcome. I know we've had this
all
discussion
of you.
before.
Yeah. Good to see everybody here. So Lori was in court today. So we're going to watch it. We're going to blind react it. Neither of us have had a chance to watch it yet. So we're going to watch it with you. We'll probably stop here and there just to clarify something or make a bitchy comment. I don't know. We'll see.
All of the above. Definitely.
Yeah. But before that, you have a little show and tell, and I wanted to go through yesterday's filing as well. So
yes. So I talked last night about my Easter eggs on Fidget Whimsy. They look like this or like this. And so many of you bought them that you bought out my inventory that was on my website. And so I wanted to make sure that you know that I have fixed my inventory. You get a ducky, a chick, a bunny, and a piglet that go in each one.
There's the piglet. That's so cute.
Yes, there's the piglet. Yeah, I hadn't finished printing piglets last night. So I have updated my inventory. So if you tried to buy an Easter egg and you couldn't get one, that would be why. So I'll put a link here in the chat to them, but they're on fidgetwhimsy.com and they are now more available. So just in case you were wondering, I realized, oh my God, I just said a number. Like I kind of make it up. Turns out maybe that's not the best way to go because I have a whole bunch of these pre-printed, but then I'm always printing more.
Of course.
So anyway, just wanted y'all to know that they're available.
Very good. Again. Love it.
Yeah.
Okay. Well, there was a filing last night. I shared part of it with you, but the copy I had was kind of cut off, and now I have a clean copy, so let's go back through it. This is a filing from Lori to the court. So the defense notices the following defenses: insufficiency of the state's evidence, self-defense, defense of others, third party at fault, mere presence, and procedural. She's really throwing everything at the wall here. That's a lot of defenses to claim at the same time that stand in defiance of each other, but okay, that's fine. And then she says the defense notices the following witnesses: A, the defendant; B, any and all individuals, including but not limited to victims' assistance caseworkers and or volunteers who have spoken with any witnesses in this case. That would be hearsay. All witnesses in the state's Rule 15 I disclose, as well as any in supplemental witness disclosure filings. The custodian of records for any and all exhibits, Nate Eaton. I don't know how to say this name. Veja, Gabrielle Bonilla, Joseph Pongrantz, Ashlyn Rind, Barry Cox, Zachary Cox, Adam Cox, Janice Cox, Summer Shislett, she forgot how to spell her own sister's name.
Oh
And
dear.
Brandon Boudreau, interestingly. Uh, the
Wow, that
defense,
should be very interesting considering
mm-hmm,
her
the
upcoming trial.
yeah, we'll be trying to kill him, so that's
Hmm.
fascinating. The defense notices the following documents, photographs, and other tangible objects that the defense intends to use at trial. Any item disclosed by the state, insufficiency of state's evidence. I'm not sure why that's in there.
Right?
The
Is
de-
that
the
like leftover from
the
another
defense
from another filing?
notices Right. The defense notices the following documents, photographs, and other tangible objects that the defense intends to use at trial. A, any item disclosed by the state, and B, insufficiency of state's evidence. Lori, what the hell does that mean?
Right. That sounds like an incomplete sentence or something to me. I'll bet.
C, disclosure remains ongoing. Ms. Daybell will supplement as necessary as this information becomes known to Ms. Daybell. So maybe she's referring to things that she doesn't think she's received yet.
I guess maybe, yeah. It's just like it's sort of a partial sentence, like she's missing some
Yeah,
verbiage.
I
But
think
I
so.
mean, she did agree with Keith Morrison that the judge would have to be very patient in this situation.
Indeed. So she was in court this morning, so we're going to go ahead and get going there. And again, we're going to just blind react it with you guys, and we'll stop probably here and there and clear something up. There were a few things argued today that I haven't watched this, but I was reading through Justin Lum's notes and noticing that some people that were commenting on his notes clearly didn't understand some things, needed some context that we definitely have. So
Ah,
we'll provide that as we go. So here we go.
Justice Clark held that failure of the state judge in murder prosecution to protect defendant from inherently prejudicial publicity, which saturated the community to control disruptive influences in courtroom, deprived the defendant of a fair trial consistent with due process. So that and Arizona versus Cheney.
I know this is really fast to jump in, but seriously, Lori, seriously, your Dateline interview just aired 4 days ago. Like,
Yeah.
Hello?
Yeah.
Sorry, I will let it go longer, but I was just like immediately like, are you kidding me? Okay,
Yeah.
here we go.
Which was the defendant is entitled to fair and impartial trial when publicity pervades court proceedings to the extent that the proceedings were prejudiced to the defendant. So obviously you read my objection, so I just wanted to add those on the record.
Okay.
Thank you.
Your prior attorneys had filed a series of objections to media coverage media being allowed in the courtroom, and I made a prior ruling that was filed back September 4th, which was fairly comprehensive. I am inclined to allow one pool camera. I'll issue an order with more detailed findings later today or tomorrow. But essentially, there won't be any media coverage during the jury selection process, and I'll put the reasons for that in the order. So that's, again, I'll issue a more detailed order later today or tomorrow. All right?
Your Honor, there's also the issue of whether Court TV would be allowed to live stream the trial, in other words, broadcast online in real time. Court TV would prefer to do that.
Are you able to, are they able to do a 1 or 2 minute delay?
Certainly, we can certainly do that. I just want to inform Your Honor, however, that when we share the footage with the pool, we can't delay that footage. So your order would need to require that all media receiving the feed delay it by, however long you wish to delay it.
And the camera, the pool camera would be simultaneously distributing that feed to whatever media requests it?
That's correct. We have the capability to distribute to up to 30 or 40 different media outlets, so we have plenty of bandwidth to do so.
It's prejudicial and it's going to be as well.
All right. Thank you.
It's prejudicial, and it's going to be.
All right. Let's get down to business on some of the,
Your Honor,
yeah.
could I just add that we want to make sure that the camera's not going to be zooming in at any level to get to our notes and the things that are going to be on the table. I also previously, what has happened before is that they just have the camera on my face the entire trial. So I think when the judge is speaking, the judge needs to be on the camera. When
So it wasn't on her, it wasn't in her trial.
No, it
There
wasn't.
were no cameras in the courtroom in Lori's trial. And the reason why, and this is why she has such a beef with Court TV, is that Court TV was in a hearing of Lori's in St. Anthony,
Right.
and they kept the camera trained on her face the entire time. She looked crazy as hell. It was the first good look at the Shih Tzu hairdo.
Yes, it was.
And
It was
she was
really
looking
bad.
off, yeah, into the sunset like she was, talking to her dead kids or whatever. It
She was reacting to
really
things that
weirdly.
weren't there.
It made her look awful. What doesn't at this point, but it was bad. It was a bad look on Crime TV's part. And that pissed the judge off so much that he kicked cameras out of the courtroom for her trial. We were
Right.
all really mad at Court TV for what they pulled there.
Yeah.
That's what she's referencing. So she said in her trial, that's not true. That's not accurate. But this is exactly what her beef with Court TV is about.
Yeah. And also, I think that they're not paying her for using her likeness in their commercials.
Oh, right. Yes, that too.
I think there's that.
the state is speaking, they need to be on camera. If we can add that to the order, I think.
All
it
right,
would
well,
be
my
correct.
draft already includes that there'll be no zooming in on council table, anything on council table, or anything being handled, notes or that sort of thing being handled by any of the parties or the attorneys. As far as what they focus on, they'll be limited to focusing on the parties, myself, the witness, depending on the witness. I need to ask the state about that in a second, but they won't be allowed to broadcast any image of any juror. While I'm on that subject, let me ask the state, are you seeking any sort of protective order when a named victim testifies?
Not at this time, Your Honor.
Will you let me know if that changes?
Yes, I will.
Do you have do you have the names of your designated victim or victim representatives that might be testifying?
Kay Woodcock is a statutory legal victim and will be testifying.
Is that the only one?
At this time, yes,
Okay,
for this
That
trial.
foot.
for this trial, okay.
She's loving this. Not.
A nice peek at those hooves. Yep.
Let me ask this, are the parties ready to proceed around March 31st or April 1st?
Yes. Yes, Your Honor.
All right, let me ask the state next. Earlier during these proceedings in past hearings, you indicated you thought the state's case in chief would take 2 weeks. You requested yesterday to screen for 6 weeks.
Your Honor, I did say 2 to 3 weeks,
Okay,
but I did say that while we had a defense attorney on and not Ms. Vallow herself. I am familiar with other pro per trials where generally the timelines are in excess of those with a defense attorney assigned. So in order to ensure that we aren't asking a jury later to stay longer than we pre-screen them, I believe it would be appropriate to screen them for 6 weeks.
so now that you're gearing up for trial and maybe you have a better idea, how long do you think your case in chief would take with a normal amount across? I know that's hard to estimate.
And again, I would say 2 to 3 weeks.
3 weeks?
That would be at the outset of it.
Okay.
Probably, yeah, 2 to 3 weeks.
Okay. Let me ask advisory council, if we do an questionnaire, would you be assisting Ms. Daybell with your laptop and going through the answers that are received?
Yes, Your Honor. I mean, assuming we do all of that, because a lot of times the courts send us back to our office to go through that. So if we do that here, then yes, of course, she's welcome to use our laptops.
All right. My plan is we can do jury selection in the South Court Tower 5C. I know that the state has requested that the entire trial be held there. We can't do it. We can do jury selection there. I can give you rooms here for your victims and witnesses as need be that are outside this courtroom that we'll have. We can have them stream in if you want, depending on, I guess, who the witness is or who's back there.
And obviously, Your Honor, I don't know if the public will be attending this or not. This also is a little different in that even in the mornings, the jury is going to be potentially out here while the court is having morning calendar. If there's media out there as well, I'm just trying to protect the integrity of the trial by ensuring that the public, the media, are not interacting with witnesses at any time while they're out there. It's difficult when it's a very small hallway and very limited rooms to put them in. Obviously, I need a room for the victims that's separate from any witnesses.
Well, we have on this floor 6 rooms, 5 or 6 rooms throughout. We have 3 right behind this courtroom, and we can utilize them as need be to ensure that there's no improper contact between media or the public in general and any victims or witnesses. We can also ensure that the jurors don't have contact. If that means we bring them up in a separate elevator and have them assemble somewhere else, we can accomplish that. So my plan will be to do an e-questionnaire, remote questionnaire for the first 200 jurors. That questionnaire, I need to get a final joint pretrial statement with the list of witnesses to include the names of witnesses in that, but I'd like to send out a draft to everyone by the end of this week. Let me bring up my calendar.
How many questions are going to be for her?
Interesting that
We
she
would probably
keeps talking
send that
with the
out
mic
to the
on.
first 200 jurors around next Thursday, March
She was
20th.
classically trained by Mark Means.
Is it already sent? The first day they can send it out the 24th.
Oh, I guess they can't send it out.
So we can do from the 24th to the morning of the 27th.
Okay, so we can send out that the 24th to the 27th, meaning it would be cut off on the 27th. The answers to those questionnaires would be emailed to the parties. That would give the parties the 28th, 29th, 30th, and 31st to go through those answers. We would meet on the morning of the 1st, discuss who needs to be let go based on those answers. Also on the morning of the 1st, a number of walk-in jurors that for whatever reason don't fill out the questionnaire in advance would come in to the jury room, the jury assembly room that morning and fill out the questionnaire. So that morning we'd also deal with those walk-in answers as best we can.
We have to meet the 31st. For the initial.
Oh, that's right. I back up. The initial answers for the remote, we're going to meet on the 31st. Let those people go. Whoever we don't let go will be told to report on the afternoon of the 1st. On the afternoon of the 1st, we'll be dealing with the walk-ins that come in the morning of the 1st. And the people that we haven't let go the afternoon of the 1st, that will be in person voir dire as needed. If we need to, which I anticipate we probably will, we'll do another 200 jurors on the 2nd. And if need be, we have another 100 jurors on the 3rd.
That next set of 200, would that be that wouldn't be a remote question.
They
That'd
don't
be
have
regular.
a capability to do it remote, so we may have to, what'll happen is on the first, all those people, after they give their answers, will be randomized, the list will be re-randomized. As we proceed through the second, those people get added onto the bottom of the list. So as soon as we get 12 jurors that qualify, that everyone's happy with, that don't have issues, plus probably 3 or 4 alternates. So as soon as we get to about 15 or 16, we're pretty much done with jury selection. So we don't have to necessarily question all 200 of those people. We can do panels of 20 or something like that. I anticipate losing quite a large number of people just based on prior media coverage and people already having some sort of opinion about the case. I normally wouldn't include a defendant's name in the e-questionnaire that goes out remotely, but on this case I'm inclined to, just because that's what we want to know. We want to know if people have heard about the defendant and whether or not they've heard about, or if they've formed an opinion about her or this case prior to that. Does anyone have an issue with that, State?
No, Your Honor, I think that that's a good idea. That's going to be at least one of the initial reasons to strike a lot of jurors.
My only issue with it, Your Honor, is that it could be bad both ways, right? If you put the name in there, if you don't put the name in there. It's been my experience that people will say they haven't heard when they know who that really is, and there's people that will want to be on this jury just for this purpose.
Yes, baby.
Your experience.
Everyone wants to be on your jury.
It's going to be complicated.
Oh, yeah.
All the research indicates that these e-questionnaires, people are more likely to give honest, candid answers than if they're in a group of people and they feel sort of that peer pressure of what's a good answer and what's a bad answer. Your name is going to come up sooner or later, so I would prefer to just get it out in front of the potential jurors to begin with. My e-questionnaire is going to be fairly basic. It's going to focus on qualifications, the charges, the witnesses, and then obviously whether they have an opinion about you or this case. For the people that make it past that level, we'll question them more thoroughly in person.
And like you were saying, as far as group kind of voir dire, in my experience, we went through 1,900 jurors in my last trial, so it would be good to do individual voir dire if we can, then group voir dire, because they learn things just in the voir dire and it disqualifies a lot of jurors.
I'm not opposed to that, but that's going to be sort of a...
Let's pause for a sec. One thing, I did look it up. I was pretty sure they can't wear, that Mormons can't wear garments in jail or prison, and it is true they can't. They have to wear, what is issued to them as a prisoner. It doesn't qualify for like religious purposes or whatever.
That's responding to a question in the chat. Yeah.
Yeah, that was responding to a question in the chat. Sorry. Also, Teresa said that they can't really hear our comments unless we've paused it. So
Okay.
thought we should do that. Anyone else find it real weird and ironic how she and Casey Anthony are taking this same tack, that they've got experience in the legal system?
Yeah.
In my experience, Your Honor. Oh, in your experience in which you were convicted of 3 murders? Like, you're not an
That time
attorney.
you were a defendant? Yeah.
Yeah. That other time you were a defendant, I thought that was pretty funny. And her implications, will people just say that so they can get on the jury? Really? Do you have any proof of that at all?
Right. So is
'Cause-
that what you're trying to claim about your last conviction? Is that
Right,
people told
like-
lies so they could get on your jury? Yeah.
Yeah. Like, listen, lady, and just because you say it does not make it true. She says a lot of things that you're like, most attorneys wouldn't say those things because they can't prove them.
Right.
And you're
Now, her voir
not
dire in
supposed to do that.
Idaho was done in groups,
It was, yeah.
but I'm not really sure why she has any kind of argument with that. There were no problems with the jurors.
She just wants to have stuff to say, I think. She's just thinking 100 miles
Yes.
an hour. Is there anything I can say?
That seems to be, I was thinking that too. She's trying to come up with things to say to be relevant. Yeah.
Because the actual attorneys in the room are kind of like, yeah, okay, this sounds pretty typical of what we do,
Right. That sounds right.
You
Yeah.
know, those of us who have real experience with the legal system and not just
Mhm.
experience being a defendant. Right, Movin? It's like she's referencing her resume, but her resume is filled with crimes she committed.
Correct.
True,
yes.
true.
Yes.
Yeah.
Right, Joelle. Most people would say they heard of her to get out of jury duty.
Yes.
Not get
right?
in.
Like, oh God, I don't want to have to listen to her.
Yeah.
Also, somebody said that they were surprised that she could say voir dire correctly. Me too,
Mm-hmm.
because we watched her trial.
Mm-hmm.
And there was a lot of voir dire going on. And
Mhm.
oh my God, I hate that so much. It drives me nuts.
Yeah.
I just say it right. Come on, you're an attorney. You went to a lot of school. Come on. Or you're a judge. You've been you've been doing this a while. Come on, just say voir dire.
Or you're
So
a
dumb.
criminal that's been at trial a few times. Yeah.
Yes. Yes, that. That in my experience that she says, what?
Keep saying that. That's hilarious. Yeah.
In your experience. Okay. All right. Anyway, I just wanted to say those things. Did you have anything?
Yes. That's where I was at.
Okay.
Day of play it by ear sort of situation, whether we do small panels or just go a single person. If we go single person, our jury selection could extend into the next week. But if we're able to seat a jury, I would expect opening statements on April 7th, somewhere around there. Does the state indicated, I have it, there was just one day in April that you wanted to go a half day?
Correct, Your Honor. The 24th.
All right. When can you file some sort of pretrial statement that sets forth all your potential witnesses and a statement of the facts?
Probably by Thursday.
All right. Does the state anticipate any presentation of autopsy photos or crime scene photos? In other words, I'm trying to gauge, I would usually put in a question about jurors may be required to view evidence that shows wounds or that sort of thing. Is there anyone that's unwilling to look at this type of evidence?
Yes, Your Honor. We will have both, obviously, with self-defense, trajectory, and those injuries are very relevant.
Okay, so I will include a question about that type of evidence. Sometimes jurors don't want to look at that type of evidence, so.
Should we talk about that for a second? The self-defense trajectory?
Yeah.
So that is the trajectory of the bullets that hit Charles. And
Right.
do they support
The story.
Alex's story of self-defense?
Yeah. Yeah.
Because especially that second shot, he was on the floor.
Yep.
Back to Alex.
Yep.
That's the part that I've always found to be really damning about this whole damn thing.
Mm-hmm.
Is how did they think that was self-defense?
Yeah.
Remember, because it marred the floor, and they could very easily see that he was flat on his face when he got that shot.
Mm-hmm.
Yeah,
Yep.
crazy.
But it's interesting she said it that way. Yeah.
Yeah, it is. Like, oh, we're gonna poke holes in the whole idea that this was self-defense to begin with. Good.
Mm-hmm. So they actually did discuss cameras with Court TV in the very beginning. This recording didn't start until a little ways in. So they did.
Yeah.
That was the very, very beginning. That guy with the long braid, he was the attorney for Court TV that was speaking. Yeah. So and basically the judge pretty much said, we're going to have cameras in the courtroom. I think he'll still issue a ruling on that, but he was pretty much laying it out how it's going to go.
Well, yeah, he said there would be a pool camera, and then he said, well, can you guys do like a 1 to 2 minute delay?
Yeah.
Which, hey, that's fabulous Let's not do a 1 to 2 hour delay because those
Right.
suck.
Those
Like a
really
1 to
super
2 minute
suck.
delay is awesome.
Yeah. Yeah.
So yeah, it seems like we're not going to have any trouble being able to stream this show.
Yeah, this is looking to me like it's going to be great.
Case.
Yeah.
Yeah. Yeah, the feed today was played on delay, I believe.
I believe it was actually shown after the fact.
Was it clear
That's
after the
how-
fact?
That's how all of these hearings have gone, is they're allowing a pool camera, but they're not releasing it until the hearing is over. So hopefully
okay.
we won't run into that kind of a thing. But a 1 to 2 minute delay, even a 5 or 10 minute delay, fine.
That's cake, man. That's total cake. But the judge asking that question, like, come on, he's making it pretty clear what he's going to do.
Indeed. Yeah.
Is her orange top ripped? Kate asks. We'll have to look. I didn't notice a rip, but we'll keep an eye on it now.
Yeah.
I see. Okay. Well, let's go ahead and go back. Sorry, you can pause too. I just keep
No, you're
thinking
good.
we should talk about stuff. Okay.
All right. Any questions or concerns about our jury selection, the proposed trial dates from the state?
No, Your Honor. Just so I have it clear, Your Honor, we're going to start on the 31st with jury selection. Is that
We'll
correct?
be meeting on the 31st,
Okay.
and then actual dealing with in-person jurors on the 1st, 2nd, 3rd.
Okay.
Robert and I.
Let me ask advisory council, are there any dates that advisory council would need to be dark?
I am fine for April. I didn't hear back from Robert. I would think.
Please let us know, because in that e-questionnaire, I'm going to put in a proposed schedule. I don't know that I'm going to screen for a full 6 weeks based on the state's anticipated presentation, maybe 5 weeks. So into let us know the schedule into the first week or two of May.
As soon as I get an answer from him, I'll email your judicial assistant.
All right.
So they're gonna. And one more time, Your Honor. So the remote question is going out on March 24th. All answers have to be back by the 27th, so we will get them on the 27th, or
You'll either get them late the 27th or first thing the 28th.
Okay.
In the morning, late in the morning of the 27th.
Oh, okay.
okay.
So I'll put it-
You should get them some point on the 27th.
Just so we can plan, because it sounds like we'll just go out to Estrella and go through these.
Yeah, they're closing it at like 8 AM on the 27th.
You'll have to have a internet connection.
Yeah,
out
we
there.
can use
Okay.
our laptops out there,
Okay.
because you want to be ready to discuss everything on March 31st.
Yeah, and if the parties have an obvious, there's some jurors that are going to be obvious that need to be let go. If you're ready for that, that's always helpful. I know it's a little bit more difficult with pro per defendant in consulting like that. All right, let me get to,
So we'll come out on Friday and go through the questionnaire. We don't get any questions on that.
all right, the defendant had filed 2 separate motions for specific discovery. The first dealt with communication between the assigned deputy county attorney and law enforcement agencies. I've read and the second one was, well, let's deal with the first one. I've read the response from the state. Basically, your response is you have disclosed all those communications. There are no other communications.
Correct, Your Honor.
All right. So let me ask the defendant,
Yeah, we received 6 email communications, and they were in a short time frame, not the full time frame. And it seems to me that in the last email, ends in kind of a question that was probably answered, and then there's like no more communication. So it doesn't make sense that there's no more. We asked for all of them if they could be provided to us. We don't understand why they're not being provided to us and what the state is possibly hiding at this point, and they can't just turn it over so that we can go through them. It's been, long over a month since we filed that motion, so we would just.
What the state is possibly hiding, because sure, if you didn't get everything you think you should have gotten, surely they're hiding it.
Yeah, that's quite an accusation to make.
Yeah.
Lori, most judges will kick your ass for saying something like that.
Yeah.
Without any backing of what the hell you're talking about.
Mm-hmm.
Oh. It's like them to please turn over whatever they have left.
All right, and I'll ask the Deputy County Attorney, I imagine some communications are by phone, so in other words, we're not captured.
Correct, Your Honor.
All right, based on the states of Vallow, I don't know, I can't tell them to turn over something they say they don't have, so. I'll find that the state, based on their Vallow and officers of the court, have complied with the request. The second one is a little more, I wanted to get clarification on. That was defendant's request for video interviews, but it seemed like based on the state's response that there was some confusion about what was a interview recorded in an interrogation room situation versus a body cam. Did the state's response provide clarification to you?
No. So the body cams were turned over, and they're in like 12-minute increments. There's like 4 different body cams. This was a full 2-hour video that was released by Gilbert Police to the public, and it's online. So I would like that video of the interrogation room, the full 2-hour one, to be turned over to the defense.
All right, so do you know what that is?
Your Honor, based upon the defendant's reply, she's requesting a video interview from the 31st. Those are on body cam and were turned over to the defense. We have requested everything from, I think that one was from actually the Gilbert Police Department. A lot of these overlap. So I am not sure what the defendant is.
Who was the person being interviewed? And you said the 2-hour interrogation that Gilbert released.
So it's myself and my daughter, Tylee Ryan, and Melanie Gibb.
And is that in an interrogation type room?
Yeah, it was at the Gilbert Police Station, and I didn't realize we were being filmed that whole time. I didn't know we were being filmed, but we were being filmed in that room.
And are you familiar with a video in a room?
Yes, that's what we have disclosed, is an interview of, it is
And you're saying you don't have it?
defendant, her daughter, and another.
And you're saying you haven't gotten that?
They have given 4 about 12-minute body cam videos of the policemen's body cams that were in the room with us, and they go in and out of the room at different times. So there's different body cams. They're all mixed up. It's not the full entire one, and the full entire, my understanding is that the full entire 2-hour interrogation room video from the ceiling is available online, but I don't have it in Discovery.
That's what I'm trying to clarify. So
I have never seen that.
I haven't either.
I don't know what she's talking about.
I think that it's very possible that somebody took those body cams and strung them together so that they
Maybe.
look like they're, something like that. But I haven't seen that either. It's very
Also,
likely it was
my
just
God,
somebody
so
that took the
dramatic.
body cam and edited them.
Mm-hmm.
But yeah, very, very dramatic.
Yeah.
The
Anyway, but yeah,
constant
I have
implication
no idea
of
what she's talking about.
malfeasance. Yeah, I'm not sure
Yeah.
either.
did the state disclose not a body cam, but an interrogation from up in the corner of a room vantage point?
We disclosed a lot. Let me see if I can find out. We did. Yes, my paralegal is present here as well, and she has advised that we did. Your Honor, we disclosed over.
Can your
Where is
paralegal
it?
provide a Bates number or something so that maybe the defense just has overlooked it?
Let me see if we can find the actual
Maybe the discovery notice.
discovery letter.
Okay.
Okay. Some people are saying they've seen it. I know that I've seen all of the interviews individually, but I have not seen an interview with 3 of them together in one room.
And
Have
Melanie
you
Gibb
guys
being
seen
one of
that?
them. I
And
have not
Melanie
seen
Gibb being there. I've
Yeah.
seen the individual interviews of Lori, Tylee, and Alex,
Mhm.
but a video that's 3 of them. And why would the 3 of them be being interviewed together by the police? That's odd. Why would Melanie Gibb be there?
Right, she wasn't even present, so I don't know.
So if somebody knows what that is,
Yeah, if you find
let
it,
us
send us a
know.
link, because yeah, I have no idea. Justin Lum
Yeah.
also had no idea.
Yeah. But I don't recall one of the 3 of them together at all.
No.
So we've seen all of those other interviews, but
But
this
then
is
again,
something
there is
else.
so much data in this case that would it surprise me? No, it wouldn't. But I'm not sure
Right.
what she's
No,
talking
but
about.
I mean, as far as it's been out on the internet, I don't know. Nobody seems to have seen one that's the 3 of them together. Unless you have, tell us where you've seen it. And we'll go find it. When they want to report Charles taking her bag. Oh, so it was
Oh, this is
prior.
well before the murder.
I'm not sure.
Well, I'm thinking murder, so I'll have to think back on that.
Right. I was thinking the interrogations when Charles was killed.
Yeah. Yeah. Okay.
Interesting. Okay.
Your Honor, all we do have is the 4 body cam. We can ask again and see if they have a overall.
Are you getting this? Have you seen this, or someone told you that there's this video?
My mitigator showed me part of that video, yes, with my previous team. That's how I know about it, otherwise I wouldn't know about it. She said, do you know this is online? I didn't have any idea.
And you're sure it's the Gilbert PD on that date?
Correct.
All right, I'll ask the state to follow up with Gilbert on that.
We will, Your Honor.
There, if that is out there, obviously it should have been disclosed. All right, remind me to follow up on that next time we are together. Next, I have a motion limine, 2 motions in limine, one regarding Alex Cox statements and one regarding Tylee Ryan's statements. All right, so let me ask the defendant, generally any hearsay is defined as any out-of-court statement offered for the truth of the matter asserted. The state is referencing what are definitely out of court statements. Obviously, there's some exceptions to the hearsay rule, and there are other things that are characterized as non-hearsay. So how do you think, let's first talk about Alex Cox. How do you think the statements fit into your, either one of those exceptions or non-hearsay?
I feel like the state is blanketing that whole thing, and obviously it's like a case-by-case basis, right, on these statements. So there is the police interview of Alex Cox that I do not think falls under hearsay.
Why not?
Why does it not fall under hearsay?
Yeah.
Because we're not using it for the truth of the matter asserted. We're using it in corroboration of the circumstances. Everyone came in and told their same story that corroborates different facts in there, not for the whole truth of the matter.
Aren't you arguing that what he said was true?
I can't say whether another person says that it's true or not, but I'm saying what he said and what my daughter said and what I said in those 3 police interviews determined what the police said, how the police acted, what they did after that, their next steps, how they treated the entire case like it was self-defense. All of those are relevant to the defense that it was self-defense. So, yes, I think they're for that purpose. But I also think that Alex's statements also have a lot of the exceptions apply. 803, 804, there's a lot of exceptions that also apply to some of his statements and not all of his statements.
Such as what? Which statements do you think they apply to?
Specifically his statements made on body cam to police in the driveway, specifically his.
I don't know what the statements are, so that's what I'm asking. What specific statements do you think are allowed to come in under the rules of evidence?
I think under 8031, the present sense impression is his statements made to police officers at the house.
A present sense impression is where you're actually observing something and you're talking about it as you see it happen. So, isn't he saying, again, I don't know what the statements are, but is he saying what happened prior? Or is he saying
Yes,
something
prior.
that he's, okay,
Correct,
so it's not a
prior.
present sense impression.
Okay.
What else?
Then I think it falls under 8032, excited utterance. He was under the stress of the whole situation when he made those statements.
What was his demeanor when he made those statements?
Pretty damn
Upset.
calm. That's what.
What's the specific statement?
I shot my brother-in-law in self-defense. I got hit in the head with a bat. There was an altercation. I don't know what all the statements are, but
How long after the incident did he make these statements?
immediately after, as far as I know.
Well, immediately to some people means 2 seconds, to other people it means 30 minutes. Tell me what immediately means to you.
As soon as the police arrived.
I don't know did they arrive 30 minutes after the incident? 10 minutes, an hour?
I was not there. I do not know what time they arrived.
All right.
She's got to be so careful with this, because remember how fucked up the timeline is about when the incident actually occurred?
Yep,
And this
and
will
that's-
trip her up hugely.
Well, you see how careful she's being right now.
Yeah.
She's
She
breathing
should not
hard.
even
You
be
can hear her in the
talking about
mic.
this. Yeah.
Mhm. And I do not know. I was not there. Uh-huh.
Yeah. What time did he call 911 versus what time did he shoot him versus what time did he get hit in the head with the bat? Lori, you want to clear all that up for us? Because it's sure not clear.
Yeah.
Not to mention, we all know she's not going to get around hearsay on this, because the bottom line is Alex is dead, and so he can't be questioned. But she doesn't want to talk about that either.
Yeah,
Yes.
they waited a fair bit to call the police. Yes.
Yeah, it could have been as much as an hour.
And that's
to call
only
the police.
if you trust their story to some
Right.
degree.
Yeah.
Yeah.
So it's very hard to know for sure. Okay, I just had to say that because I'm like,
Yeah.
oh, she's gonna. I'll bet that the prosecution's like
Right.
keeping an
'Cause this
eye
is a
on
dicey
this.
spot. Yep.
This is super dicey. She shouldn't even be talking about this, honestly.
Also, 10 high fives to the judge.
Let me,
Yes.
so you're asserting excited utterance, some of these statements come in, what else?
8033, the mental, emotional, and physical condition, because it shows his state of mind, which was scared at the time.
Any
Wasn't
others?
scared.
Yes. 8035B, the recorded recollection. I know that in the state's reply to my response, they did not think that 805 applied because A, B, and C, but I did not see an and after A, so my assumption was that B and C, since there's an and after B, were what needed to be put together. So B was made or adopted by this witness when the matter was fresh in the witness's memory and accurately reflects the witness's knowledge. So I felt like 803B, 5B, the recorded recollection of his police interview and the body cam footage applies under that exception.
All right. Generally, 8035 is a recorded recollection, meaning it's something they wrote down, or maybe they recorded their voice saying something. Let me ask the state to respond. We're just talking about the Alex Cox statements.
Your Honor,
Maybe I should start with,
Yeah.
does the state intend on introducing any statements from Alex Cox?
Your Honor, I haven't decided if we will at this point. I can say with 100% certainty, we will not be admitting his interview by police that was done at after 10 o'clock in the morning. We don't,
Are you referencing what time he was interviewed versus the time of the incident?
let me say it this way. So the state has laid out in its motion the timeline. So that is actually in our motion. We show that when
8:30.
Hang on. One thing we got to remember too at this point is that there is a real discrepancy around when did both shots occur, because she implies that they occurred simultaneously, one right after the other. But Tylee's statement said she heard one shot.
Right.
So did he put him down with one shot and then come back later and realize he wasn't dead, laying on the floor, and shoot him again, which also messes with
Right.
this whole timeline thing. So, and I'll bet that's all going to come in with the prosecution, but you got to think about that with what she's trying to say here.
Mm-hmm.
We don't
There's a
even
big
know when those
discrepancy
two
right
shots
there.
actually occurred.
No.
Yeah. Okay.
AM
is when the
roughly.
911 call was made. So we have soon after that, the police arrived and there's body cam video from that interview. Then Alex Cox is later brought to the police station and there is a in-depth interview with detectives at a little after 10 o'clock in the morning.
So you may or may not be attempting to introduce statements at or around the time that the police responded?
Correct, Your Honor. If we do, those would be brought in as co-conspirator statements against a party interest. So obviously the state can bring in statements that are hearsay against a party.
Right. But I guess, is the state intending on introducing any statements of Tylee?
No, Your Honor. Tylee made no statements at the scene other than giving her general biographical information on body cam. Her entire statements were made at the police station, again, after 10 in the morning.
All right. So on your response as it relates to Tylee, you say, again, present sense impression. I don't think it's a present sense impression. You also argue excited utterance. What else?
8033, which is mental, emotional, and physical condition, with the same thing, her state of mind, then being scared. And also 8043, statement against interest. They use that statement in the indictment where Tylee says that Charles says, if you hit me with that bat, you're going to jail. That's the part where she's nervous in her interview, saying she's scared to tell the police that she's the one that brought in the bat. So state of mind and the statement against interest both apply to Tylee's
All right.
police interview.
All right. Anything else? Does the state want to be heard further on that?
Your Honor, the only further thing I think that the state will bring in is that obviously the defendant has been found guilty of killing both Tylee, other individuals, but in this case, the defendant cannot benefit from killing a witness and then later try to bring in their statements for their benefit. So in addition to none of her statements being admissible under the rules of evidence, as any of the exceptions that the defendant has done, we also believe that it would be improper for her to be allowed to bring them in under that theory.
In other words, there's been a judicial finding that the reason Tylee's unavailable as a witness is because of the defendant's actions.
Correct, Your Honor. There has been a jury trial and she has been convicted of that.
All right. All right. The court is, on a preliminary basis, precluding references to Tylee Ryan's statements, any statement made by Tylee Ryan. If there's some reason where a door might be open to any of those statements coming in, the defendant's requested to make a request outside the presence of the jury regarding that, and we'll deal with that outside the presence of the jury. On Alex Cox, I think that's probably going to be more of a statement by statement basis, but I'm skeptical of any statements coming in hours after the initial police response. I think we'll deal with what statements may or may not come in when the police first arrived on scene and or the 911 at the time that they're attempted to be introduced.
Did you catch that the prosecutor almost said that Lori's been convicted of murdering both Tylee and Alex?
And then she backed it up. Yep.
Boy, she caught it quick, but she almost said that out loud. Yikes.
Yep, she did. But I'm so glad that she said the words,
Yes.
that she does not get to benefit from Tylee's words. She murdered Tylee. And
Right.
that's exactly what we were saying too, and that's obviously correct, but you don't get to kill somebody and then use their testimony to try and help get yourself out of trouble.
Right. Like, come on. Yeah, that definitely needed to be said.
Absolutely.
But, prosecutor almost made a big accusation there.
Yeah,
Glad
she
caught
did.
it.
She really about slipped.
Yeah. I'm sure everyone knew where that was going, but was
Uh-huh.
like, oh, shit. Yeah. All right.
All right. I also received yesterday state's notice of disclosure and request for disclosure. Did you get a copy of that?
No,
You haven't seen that yet?
no.
I'm sorry,
State's notice of disclosure and request for disclosure. I didn't realize it was actually filed in January, so you should have seen that. I misspoke when I said I got it yesterday. It was filed January 16th. Have you seen that?
I'm looking it up. What are we? Dates
I
disclosure?
think the court may have ruled on that one, Your Honor.
Well, I don't think I ruled on, at the very end, You're requesting, she submit to fingerprints, palm print, footprint.
Oh, that's, okay. I think that was prior, yes, significantly. So that would be to tie her to any of her.
Is that for other conviction purposes?
Correct, yes.
All right. And when did you want to do that?
What is that about?
If we are going to be here on the 18th, we can take them then.
I don't know that we need to be here on the 18th.
And obviously, I was unaware we were going to set this because we set it
Right.
just recently, so. I don't know if we can keep that on just to take that.
Okay, what about the state, you requested copies of any recorded statements made during interviews conducted outside of your presence. Is there any of those, were there any interviews conducted by you or your team? Of
So
any,
far?
were there any interviews conducted of any witnesses out by you or your team that you're aware of?
So far, not that I'm aware of.
All right. Do you plan on calling any experts to testify?
We do plan on calling one expert.
Who's that? Has it been disclosed to the state?
We are, yes, we're working on that today as an addendum to the
Who's that?
witness list that, Lonnie Dworkin.
All right. That's your investigator?
No, my investigator, Jeff White.
Oh.
That's the expert.
What kind of expert is Lonnie Dworkin?
Phone and digital.
I think I remember his name. Are you aware of that?
No, Your Honor.
All right, expert reports and disclosures are due 30 days before trial generally under the rules, so if you're planning on using that witness, you need to get that disclosed right away, and I may have to take that up depending on what the state's position is. But
Your
at this
Honor,
point,
that-
it's technically late.
May be another reason to be here on the 18th. Obviously, if that's disclosed this week, we can potentially address that issue on the 18th.
All right. Let me ask the defendant, do you have a position on the taking of prints and photographs? Generally, identification type things are permitted over any defendant objections. So do you have a record you want to make on that?
Not really.
All right. I don't see any
For
reason
what
why.
purpose? I don't understand.
In the event that you're convicted, it may be used to prove other convictions. That reminds me, is the state planning on proceeding in the second trial regardless of what happens in the first trial?
I believe so, yes, Your Honor.
And how much time would you need between the conclusion of the first trial and the start of the second trial?
Your Honor, I would say at least 30 days since we do need to actually subpoena out-of-state witnesses for the second trial.
I'm wondering if it wouldn't benefit everyone to go ahead and set that, a provisional second trial date now.
That's fine, Your Honor.
May 11th is still my last day.
Is that second trial,
Right.
how long do you think it would take the state to
Probably
present?
about 3 weeks as well.
Similar?
Not gonna work. Your Honor, I'd like to remind the court that the last day is May 11th. Oh, yeah, there's that rule.
Well, I'll probably exclude some time based on the fact that you can't do two trials at once.
The state could combine the trials and do two trials at once, but they don't want to do two trials at once, so it really violates my speedy trial rights if they do not give me a speedy trial by May 11th for both cases.
Not to mention that they did combine all the discovery into one case. They didn't give me two different separate discoveries for two different cases, which would be much more convenient considering the voluminous amount of discovery that they piled onto us.
Does the state want to do combine both cases?
Voluminous! Voluminous.
Luminous has entered the
We
building.
finally heard Lori Vallow say it. Oh my God. Also, she is such a little shit.
She really thinks this is like down to the day, and it just isn't. There's so many
No.
reasons why they can bump this out,
Yeah.
mostly because of the defense.
Yes. Yeah. Totally because of the defense. That, oh my God, she's a little shit. She's talking like she was talking to Keith Morrison.
I
That-
did, by the way, put a link in the chat room for Lonnie Dworkin for his business, her supposed expert. There's a link in there if you guys want to go look at it. We'll do a little more learning about him. Looks like he's
That's
in
pretty interesting
Phoenix.
that she's got, like, I don't know. I'm trying to make sense of the nonsensical again.
Yeah.
Wow. But yeah, that was so rude. Anyway.
Yeah.
And of course, we had to celebrate voluminous because it's the first time we've heard a defendant say it.
That's true.
And it's the virus has definitely transferred from Idaho to Arizona. So that is
Indeed.
fabulous.
Your Honor, if the court gave us a little time to work it out and the defendant wants to join them, I mean, obviously,
I don't know that
the normal defense attorney, and I don't mean that in any way, normally they would be severed.
because you don't want one jury to know about the other
Correct.
two separate charges and have a harmful rub-off effect of the evidence in one case affecting the evidence in another case.
Correct, Your Honor. That's why they were filed separately. But if the defendant wants them together, the state would have to request this be pushed back slightly so that we could then get all the witnesses for that trial together, since they were not subpoenaed for this trial. But if that's what the defendant wants to join them, and she understands that prejudice and that she's then going to be waiving that prejudice with that, then the state is certainly willing to do that. But we would then have to request to have that trial, or this trial date moved back to allow us to get the other witnesses lined up.
Did you see that her consultant has finally started muting them?
Yeah.
By the way, Lori, this was for your benefit that they split these, dummy.
And now her consultant is furiously whispering to her about whether or not this is a good idea, Lori.
Shut up, you dumbass. Yeah. You want this jury to hear about both these crimes, lady? You really don't.
That's not what I was saying, to combine them. I'm just saying, give me my second trial by May 11th. So the court can figure that out.
Oh.
I'm going to waive some time on that second trial over the defendant's objection. Primarily, again, the defendant can't try both cases at the same time. Secondly, I'm not sure how much actual prejudice there is with a time violation, in the sense that you wouldn't be released from custody anyway. And thirdly, the rule for time violations under Rule 8, I think it's 8.6, is that any violation should be a dismissal without prejudice unless there's an actual prejudice shown, in which case the state could just refile the charge. Regardless, I think some time is warranted to be excluded because primarily you can't try two cases at once. What if we set a start date for May 12th? I realize that's could potentially be a quick turnaround, but again, I don't think this case is going to take 6 weeks.
Your Honor,
We can adjust that as necessary.
I, again, am going to ask for a longer time. I believe this will go through the beginning of May, and to have the state try to get those witnesses lined up and subpoenaed while in trial, I don't believe is.
Well, if I push it out any further, the parties need to be aware that I won't be trying the case. I don't think I would be anyway. I'm rotating at the end of June. And given some of the trainings I have to attend in June, I don't think we could get it done.
Well, both parties could send out subpoenas now for that second date for May 12th, correct?
Well, that's assuming we're done by about May 1st, probably, in this case, the first case.
And then, Your Honor, I did indicate that the state needs to be dark in May, the 21st, 22nd, and 23rd.
You said 21, 22, 23?
Correct.
Of May?
And I would need to be dark the 19th, 20th, and 21st as well, so.
So given that we would be dark that entire week anyways, it really doesn't make a whole lot of sense to.
All right, sorry to interrupt. Let me speak with the criminal presiding judge about scheduling the second trial. We can discuss it on the 18th. Let's keep the 18th, but let's move it to later in the morning. Actually, let's move it up. All we're going to do is discuss a couple matters, and then there's no reason for the fingerprinting and stuff to be broadcast or on video, so I'll prohibit that from being recorded or otherwise broadcast. So have your person here. Let's do that at 8:15 a.m. on March 18th. And then we'll also discuss whether the defense is disclosing Lonnie Dworkin as a witness and whether or not he has a expert report prepared and disclosed at that time. I will have the questionnaire for you by then, so you can review it. Anything else we need to discuss that I've forgotten about from the state's perspective?
Your Honor, I showed two other motions that the defense filed that I did not see rulings on by the court. They were both motions to dismiss. One of them only related to the 2022 case, I think. No, I'm sorry. Both of them related to both.
What's the filing date?
January 14th for one of them was an 8.2 speedy trial one. And February 4th, which was an extradition rule 8.3.
February 4th. Okay, so the motion to dismiss CR 2022-001242 for lack of speedy trial, I ruled on January 24th.
Okay.
That minute entry was filed January 24th, and then the motion.
That just seemed to get.
Was that the motion to dismiss CR 2021 and 001704 and the other for violation of Speedy Trial Act?
Correct.
That was ruled on.
Yeah, remember this? This was when the judge reminded her that the entire reason that speedy trial was, they were having to delay, was because of her and her
Right.
changes in attorneys, her competency issue, and then her becoming pro se.
Mm-hmm.
Like
Yeah.
all of her implications, they've done something to her, are 100% her own fault.
Right. But she disagrees with what the defense did at that time, or at least that's what she says now. So that shouldn't count.
You can't go backwards.
No.
That's not allowed in law. You can't go backwards. You have to go forward, and you can only go forward with what you have. And
Right.
to violate speedy trial, they have to prove prejudice, which means that things were done intentionally to harm the defendant.
Right. And
Never
like you
going to happen
said,
here.
you're not going to get released anyway. So
Right.
this is
You're in
not
jail
what
no
you
matter
think
what.
it is. Right. It's
Yeah.
just that same, I don't think that means what you think it means argument, 'cause
Very much so.
she's trying to be a real stickler on a date that she thinks is hard and fast, and it just is not.
No, it just isn't. Right. And the hot mic is killing me, man. And and even now the consultant is back to forgetting to turn it off. Like,
Mm-hmm.
not smart, but like bringing this up and arguing it again, like the judge is like, Jesus Christ.
Mm-hmm. But Lori
Can
was
we be done?
classically trained in the Mark Means School of Law. So
Yes, she was.
does anything surprise us?
She also did witness some of the John Pryor School of Law as well.
Yes.
Before the cases were severed. So she seems to be behaving quite a bit like both of them. Certainly not like her prior defense attorneys at all.
No.
On February 25th, so last week,
Okay.
a week ago. Anything else from the state?
No, Your Honor.
Anything else from the defendant?
Yes, Your Honor, I have one kind of housekeeping matter that I wanted to ask you about. I know that MCSO has some security restraints, the things that I have to wear during trial, and
I meant to
I wanted
discuss
to ask about that as far as, am I going to be able to stand at the podium to talk to witnesses, to question my witnesses and to cross-examine, or am I going to be able to move about with the leg thing and the shock vest and all that?
You're going to stick to your table and you can go to the podium. Okay? When you're giving your opening statement and closing argument, you'll stay by the podium.
Okay,
And if you need to hand a witness an exhibit, your advisory council will do that.
okay. Or my paralegal can do that too?
Well, is your paralegal going to be present here designated as your, I guess they can be present. I'd prefer advisory council to be the one that approaches witnesses if you need to hand an exhibit or something like that.
Okay, we got to have a pause for shock fest.
See, I was hoping for shockles, but a shock vest is even better.
You guys, what if they have to use it? I mean, what?
I have a lot of questions. A, does it make you pee your pants? B, who has the remote? C, can it be hacked?
Is it like those dog collars that you can turn it up and down?
True.
Depending on the...
And do they have to give her some shocks to get it gauged correctly?
Right, yeah. Like, does it have to be calibrated? Oh my gosh. Definite bingo square. Oh my God. That is great news. Absolutely excellent news. That at any moment, if she steps out of line, it'll be one of these.
She tends to forget that she's been convicted of 3 murders.
She kind of does, and doesn't seem to think, recognize that the people around her are like, this bitch is dangerous.
Mm-hmm.
Because
This bitch
she
is crazy
is.
and scary because she doesn't see herself that way. Yeah.
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 Okay, I know we're almost done, but I was dying over that.
Okay, so I'm going to be standing there, and if she's sitting here, she's going to come get something from me and go walk it over to the witness and then come back?
Correct.
Just the logistics of it?
Yeah, and there'll be a table or a cart here that'll have all the exhibits on it within reach of the podium. So,
Okay.
anything else?
Your Honor, do you use case lines for exhibits?
No.
Thank you.
I think they're still working out the bugs on that. So,
Do we need to have our exhibits in by 6?
All right, we'll see you at 8:15 on March 18.
So she can mark on.
Be at recess on this matter.
It's usually like a day or two. Like you could probably. Why don't we make up?
All rise.
Okay. Well,
We were doing them at the same time. Go with me for just a moment. Can Kay Woodcock please just have the remote to the shock vest for like a minute, 60 seconds. Give her 60
That's all she
seconds,
needs.
please.
Yeah.
It will be the most satisfying moment of all of our lives.
There you have it, though. That's Miss Lori in court. Oh, this trial's going to be crazy. I don't even. Wow.
The
Yes.
shade from the prosecutor who's like, listen, Your Honor, this bitch never shuts up. We're going to need a lot of time. Oh, man.
Well, yes, you don't get to approach the jury or the
Right.
witnesses because you're too murdery, Lori. You don't get
Yeah.
to approach them.
Yeah.
Surprisingly, ain't nobody wants you anywhere near them. Oh, my goodness. This is wild.
Yeah.
So
It is
be geared
super
up
wild.
for Brandon's trial to commence very
Very
quickly.
soon after.
And Lori, you are crazy to not want the same judge because he has treated you very well.
He has.
And
And
another
also,
judge
if
might
they
not
have to-
give you nearly the considerations he has.
Well, and it may mean that second trial gets pushed further out too.
Right.
If it's a new judge, they may have already other cases on their calendar. Like,
Yeah.
It's not going to be faster that way
No.
by any means.
Nope. So, yeah, that was hilarious after her counsel was talking at her that she's like, well, I mean, we don't want to do it. I'm just saying they could do it. That's all.
Right. That's not what I meant.
Okay, honey, but that's exactly what you said. But then when they dangled the carrot to give her what she wanted, suddenly, her poor little counsel's over there going, holy shit, you
Oh my
do
God.
not
Shut
want
up, shut up,
this.
shut up.
Yeah.
Yeah, because I mean, already you have the reality of why isn't Tylee testifying in this case? Why isn't Alex testifying in this case?
Yeah.
Yeah. Why isn't your lover Chad testifying in this case? Like, there are many questions.
I was still really hoping that he'd be called to testify from prison, but
Right. Me too.
I really wanted to see her cross him.
Well, right. I mean, you think about, like, remember the funeral home call, the cremation call? Like,
I mean, in my opinion, Chad should be called as a witness, but we haven't seen the state's witness list, so
no, we haven't.
I don't think they'll call him, but at the same time, wow, that would be
Right.
a day.
Yeah.
And his
Can she
creepy
call
blessings
him as-
voice, right?
Oh, right. Ugh. Well, and can he be called? Well, he's facing appeals right now
Mm-hmm.
in his other cases, but he's not charged in these.
Right.
So I think probably he could be.
I don't know why he couldn't be. I don't know, unless there's something I don't know, but I would assume so.
But I don't know what the benefit would be because he's just such a liar that,
Well, because of the text between them.
yeah, their communications. And I think that phone call too,
Mm-hmm.
after the fact, when he called, made that weird, remember when he forgot
Mhm.
to use a fake name and then started using.
And the text to him letting him know that she had talked to the insurance and that Kay had
Mm-hmm.
been named as the beneficiary, that her heart was ripped out of her chest. Yeah,
Yeah.
all of those things. Yep.
Mm-hmm.
We believe they are still married. Yeah, at least she
Mhm.
claims they are. So I believe that's
I mean,
true.
they would have to have attorneys that would file a divorce for them.
Mhm.
And
And that
these are
has
criminal
not been done.
attorneys they have, not civil
Yeah.
attorneys. Can his texts come in without him? I think they can.
Yeah, I think probably the whatever agent pulled those should be able to be on the stand.
If
Yeah.
it's Doug Hart again. The thing is, he could be, and we don't know, but he could be considered an unindicted co-conspirator. Because these are conspiracy charges, and it's possible that he's actually named, just not indicted.
Mm-hmm.
Because that would get him around the hearsay rule on the text.
Yeah, for sure. Yep. Well, guys, that's what we've got. So we'll be back tomorrow night at 6 p.m. for case updates, and we'll talk about, some other cases besides this nonsense. And we'll talk about more of this then probably too. So we'll keep an eye out for everything that was discussed today, including the video. It sounds like maybe that video exists. Jess shared something with us, so we'll see if we can make sense of it.
Well, and it was like, it's not about the murder. It was way prior to the murder.
Yeah.
That's what was confusing to me, and I think confusing to the prosecutor too.
To the prosecutor too. That's what she was looking for. Yeah. That wasn't clear, that this was way back, months ago. Yeah.
Right.
So at any rate, yeah, we'll work on all of that, and we'll be back tomorrow at 6 p.m. So thank you so much for being here. This has been yet another production of the True Crime Squad.
Bye, everybody.
Season 6, we're back again. Kristi and Katie, your crime time friends. Stories, justice, laughs collide. True Crime Squad, come join the ride. Grab the clues, let's take a stand. For victims' voices, hand in hand. True Crime Squad, it's time to shine. Season 6, your turn, your time. True Crime Squad, where justice meets hilarity.